The first matter to come before the court this morning is State of Ohio versus John McMullen. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, if you let me know ahead of time, I'm putting the clock this morning. We have read the briefs and are ready to proceed if you are.
Good morning, may it please the court. My name is Catherine Ross-Kinsey and I'm representing the appellant John McMullen this morning. I'd like to reserve 3 minutes for rebuttal, please. We are here on a sentencing issue. Mr. McMullen pleaded guilty to 3 counts of rape to his indictment, which included 3 counts of rape in violation of Revised Code Section 290702A1B. His indictment additionally contained the fact that his victim was less than the age of 10. However, his indictment did not contain a sexually violent predator specification, nor did it contain any facts regarding threat, the force or the threat of force or serious physical harm to the victim. Mr. McMullen was sentenced to 3 concurrent sentences of 25 to life. And here the state has conceded that there was a sentencing error in this case. Mr. McMullen agrees with the state that there are 2 subsections found in RC 297103 that contain the sentence of 25 to life, where both of those subsections are inapplicable to Mr. McMullen. Therefore, the sentence of 25 to life is contrary to law for Mr. McMullen. The first section that contains a sentence of 25 to life can be found in 297103A. In order to be sentenced under 297103A, an offender must plead guilty to or be convicted of a sexually violent predator specification. That did not happen in this case. Mr. McMullen's indictment didn't include such a specification, nor did he plead guilty or was convicted of such a specification. Therefore, that section is inapplicable. The next section that contains a sentence of 25 to life can be found in 297103B, specifically B1C. In order for an individual to be sentenced under that subsection, the additional facts of force or that the offender purposely compelled the victim with force or threat of force, or that the offender was previously convicted under the subsection, or that the offender caused serious physical harm to the victim must also be present. None of those facts were pleaded to by Mr. McMullen, so therefore he did not admit them. Those facts were not included in his indictment, nor were they amended into the indictment. Therefore, that subsection is inapplicable, and Mr. McMullen could not have been sentenced to 25 to life under that subsection. Because neither of the subsections that provide for a sentence of 25 to life are applicable to Mr. McMullen, sentencing him to a sentence of 25 to life is contrary to law, and he could not be sentenced under those subsections. This court has the power to modify a sentence that is contrary to law. Mr. McMullen's indictment and the plea to his indictment containing the additional fact that his victim was under the age of 10 parallels specifically the subsection 297103B1B, which provides for a sentence of 15 years to life. Because the trial court declined to use its discretion to sentence Mr. McMullen to life without parole, it was then mandated to sentence Mr. McMullen under 297103. The applicable subsection to Mr. McMullen is 297103. B1B, which contains a sentence of 15 to life. Therefore, this court could modify the sentence for Mr. McMullen from 25 to life to 15 to life. Alternatively, the court could remand this to the trial court for resentencing to an appropriate sentence that is not contrary to law.
What happens on remand? Does the court have the discretion to permit the state to amend the indictment at that point?
Mr. McMullen has not moved to withdraw his plea, or to withdraw the plea, and the state has not made a similar argument to withdraw the plea, so the plea stands to the indictment. So an amendment would require the state to would require the withdrawal of the plea, which neither of the parties has moved for at this point.
And the state of the law as you understand it, and I'm assuming that the state of Ohio does not disagree, does not permit the court to impose this level of sentence, notwithstanding the fact that it is an agreed sentence.
Yes, but even, it is an agreed sentence. Mr. McMullen agreed to the sentence, and the court did impose the sentence as agreed to, however, without the additional facts. That's essentially the elements of the crime that are essential elements of the crime to be convicted to be sentenced of 25 to life would mean that this sentence is not authorized by law for Mr. McMullen. Those additional facts would have to be present for this to be an authorized by law sentence, and therefore, because it's not authorized by law, regardless of the fact that it was an agreed sentence and that the sentence was imposed as agreed, it is not authorized by law and therefore can be appealed. If this court does choose to remand for resentencing, Mr. McMullen would ask in addition that the court allow him to submit an affidavit of indigency and request the court consider waiver of court costs, as that was not done at trial. That would require the court to find that Mr. McMullen's trial attorney was ineffective for failing to make such a motion. And then on remand would allow Mr. McMullen to submit an affidavit of indigency to the trial court and ask the court to consider waiver of court costs, which the court did not previously do. If there are no further questions, I'll reserve the remainder of my time for rebuttal.
May it please the court, Assistant Prosecutor Rachel Richardson on behalf of the state. We stand here today asking the court to either keep Mr. McMullen's sentence the way that it has been imposed by the trial court. The parties that were present there were in the best instance to understand the level of severity of this crime and the nature of the agreement that the parties entered into. This agreement had maintained the same from the first day of trial, prior to the trial actually. In fact, the first day of trial, it was made on the record that this was the agreement of the parties. The trial commences. Testimony is elicited from several parties, and prior to the 6-year-old victim who was going to be testifying against her father figure at the time, the person that was watching her while her mother was working, an agreement was made that prior to her testimony, instead of the life sentence that was already in front of him, a reduced sentence of 25 years to life would be instilled. This, though, is the time when the parole board would even be able to review his case. This harm to him would be lesser if we maintained what the court intended. If we actually reverse it and make it go to 15, it doesn't honor the agreement of all the parties, which includes the agreement of the mother of the victim in this case, the detective who investigated the case, the defendant, defense counsel, and the prosecutors on this case, all of whom informed the defendant of this agreement, notified the defendant of this agreement in writing, and a thorough investigation was conducted by the court into whether or not the defendant understood the terms of this agreement. At no point in time was it ever raised that the defendant was agreeing to a term that he could not agree to. Technically, the statute does allow for 25 to life. However, it would require an additional finding that this court made on the record to some extent, or at least reflected that it understood that there was an intention that the defendant had caused severe harm to the victim in this case. A 6-year-old who the whole intention was to not make her suffer more by testifying at trial.
What is it that you refer to when you say that the court acknowledged that there was
Harm?
harm to the child?
I would say on page 404 of the record, the trial court states, the court certainly agrees with Ms. Potts that, and Ms. Potts would be the victim's mother, that you know the fact that Ellie, which is the victim, will not have to testify is the basis that the court also would accept the negotiated plea. As I've told others, Mr. McMullen, the actions of raping a minor child, it's a lifetime sentence for them. The young lady is going to be impacted the rest of her life. It's certainly the most serious of offense that come up with the court other than murders, and certainly I wish the young lady well in her recovery. The court then goes into an analysis of Criminal Rule 11 prior to sentencing the defendant in felony in the first degree.
So the statement by the court that the young lady would be affected for the rest of her life?
Correct. The sentencing statute also pertains to the age of a child between the ages of, up to the age of 10, if the child's under the age of 10. In this case, the child is at the age of 6. Being able to have a child at the age of 6 versus 10, the statute also gives a lesser sentence if the child is about the age of 13. Obviously, the statute intends for more severity to be given when a child is of a lesser age. The statute does not say anything for children under the age of 10. However, in this case, when the child is of the age of 6, the defendant is the father figure of this child. The mother has had to change her entire life. In the interest of this child to not suffer further, the court and the defendant agreed to not make her testify against him. He actually benefited from this agreement by not having the sentence of life, which was currently holding over his head. He chose to make this agreement. He stipulated to the agreement. He did not raise at that time any argument that he didn't harm the child, any argument that he didn't commit the act of rape, any argument that 25 years was too much time. He didn't make a request for less time. He didn't request that the trial court show leniency. He didn't request that the trial court make any decision other than what was agreed to. And in fact, what the trial court did in this case was exactly what all parties had agreed to here. The trial court had discretion, as was noted by the defendant, to impose the maximum. However, that's not what the trial court did in this case. And for the same reasons that the trial court could have imposed the maximum, yes, it could have imposed a minimum, or it could have imposed this 25 to life with the understanding that the defendant had committed this extra act of harm, that being that severe harm was imposed on the defendant. There are no findings required when there's an agreement made by the parties, and the cases cited by defendant do not apply to agreed sentences or when testimony has been heard prior to the imposition of an agreed sentence. In this case, testimony had been elicited by several witnesses, which was consistent with the findings of the court, was consistent with a showing, including that of a doctor and a social worker, of harm to the victim in the case. And when that, in addition to what the court was able to review by speaking with the victim's mother, reviewing the victim's testimony and initial motions, the trial court was able to determine what sentence would be appropriate for the defendant.
Did you cite in, I'm just looking at the state's brief, a case for the proposition that there are no findings required where the plea is entered pursuant to an agreement?
I did not cite that case.
Is there such a case that you're aware of? It seems like it would be relevant to this appeal.
Well, Your Honor, I believe in State v. Underwood, there was reference to the no need for findings in addition when there was an agreed sentence pertaining to allied offenses. However, I'm unable to find that exact portion at this time. I do know that State v. Underwood is a relevant case to review in this matter. However, it does pertain to allied offense issues, which wasn't raised in this case, although the defendant was convicted of 3 counts of rape. The sentence of that was run concurrently, as opposed to having each of them served back to back. Are there any questions from the court? If there's nothing further, we would request that the sentence of the defendant be upheld, and if not, that this case be returned to the trial court to remedy the issues before it. When the trial court is able to review again the sentence before it, it may decide to impose the maximum term and overrule what the defendant has requested of the trial court to impose. And the trial court's within its discretion to decide whether or not to instill the agreed upon sentence. By the same token that the trial court could impose a 25-year or a 15-year. Thank you, Your Honors.
Just have one issue that I'd like to address. The state contends that the trial court did in fact make a finding of harm that would allow it to impose the sentence of 25 to life. However, because Mr. McMullen pleaded guilty to the indictment, any additional facts that would, if the trial court tried to make additional facts in order to impose the 25 to life, that would be impermissible judicial fact finding under Apprendi and Elaine. That issue is not before the court at this time and did not happen because, as the state noted, those facts were not actually found on the record in the state's sentencing entry in the journal. And if the trial court had attempted to make those additional findings in order to impose this 25 to life under United States Supreme Court precedent of Apprendi extended to minimum sentences through Elaine, that would have been impermissible judicial fact finding because the facts as admitted to were just the facts contained in the indictment. Those are the only facts that could be used to sentence Mr. McMullen. If there are no other questions, I think we'll turn. Thank you.
Thank you. Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website.
Thank you.